morning, ladies and gentlemen. We'd like to get started. I'm Laurel Evans, a program planning lawyer with the Law Society's Continuing Legal Education Department, and I'd like to welcome you to today's program, Hot Topics in Criminal Law, Part 2. I'd like to begin by taking this opportunity to thank today's faculty, not all of whom are visibly present here this morning, for their time in coming here to speak to you today. As you may be aware, CLE is a nonprofit arm of the Law Society, and we rely upon the generosity of faculty such as today for their voluntary time and effort in presenting these programs to you. Now I'd like to introduce to you one of the co-chairs of this morning's program, Mr. Earl Levy. Mr. Levy practices in the area of criminal law. He has graduated from Osgoode Hall Law School in 1963, and he was appointed Queen's Counsel in 1977. He was designated a specialist in criminal litigation in 1988. He has lectured and participated as a panelist and given trial demonstrations for numerous organizations. So without further ado, I'll turn the program over to Earl.
Good morning, ladies and gentlemen. We have gathered today for you a group of lawyers that will make the O.J. Simpson team look like a bunch of paralegals. If I may introduce the moderator of our group, Austin Cooper has been practicing, believe it or not, for 41 years, and he is not burned out. That's probably thanks to the fact he takes 4 vacations a year and has Peter West, Steve Skirka, and Mark Sandler to assist him. Austin has been involved over the decades in many high-profile trials, and in my view is the dean of the criminal bar in this province. His latest victory was the fact that he managed to get Ken Murray off the record in the Bernardo trial. Anyway, I'll ask Austin to introduce his panel.
Thank you, Earl. One of my earlier victories was getting Earl to go to watch the Rolling Stones in the rain. He stood there, water dripping off his hair. To my left, among the panel, is Michelle Fuerst, who's a partner in the law firm of Gold and Fuerst. And she does only criminal and quasi-criminal litigation, and Michelle has been certified as a specialist in criminal litigation. She's chair of the National Criminal Justice Section of the Canadian Bar Association, a director of the Advocate Society, and a trustee of the County of York Law Association. She's been an instructor both at the bar admission course and in trial advocacy at the U of T Law School, and has been a member of the faculty of the Federation of Law Societies, and a very experienced person who's co-editor of one of the criminal codes, and very difficult to get hold of Michelle because she's always either on a panel or lecturing somewhere to somebody, and really devotes a tremendous amount of her time to assisting us in the profession to learn a little bit more about our business. To my right, or to my immediate left, is Paul McDermott, who's an assistant Crown attorney in the Toronto office, and he's been there since his call to the bar in 1986, and lectures frequently at the bar admission course in advocacy and in criminal law. And he's been at various conferences and educational programs that have been conducted by the Crown Attorneys Association. To my right is Mr. Humphrey, David Humphrey of Greenspan Humphrey, and he was called to the bar in 1985 after attending the University of Western Ontario. He knows both sides of the business, was with the Crown Law Office for a little while, and he entered private practice in 1987, and he is a director of the Criminal Lawyers Association. All a very experienced panel and a knowledgeable panel. And perhaps without too much ado, because our time is limited, we should get to some of the topics that some of the panelists will be discussing today. And I wanted to ask, disclosure, of course, is a current issue ever since Stinchcombe. And in most jurisdictions, I expect, and the panelists can correct me if I'm wrong, disclosure is not a problem. And I want to ask Dave, having gotten disclosure or not having worried about getting enough disclosure, what further investigations, Dave, would you consider undertaking beyond that which is given to you by the Crown?
Well, disclosure is just one of the sources of information early on in a criminal prosecution. The other source, of course, is the client. I think the client should be exploited as a source of information early on in the criminal prosecution. I think it's important that you have your client in, you ascertain from the client and from what little disclosure you may have the general nature of the allegations, and in some sense get the general position, at least, that your client is taking. And then you can determine whether there are any witnesses that have to be interviewed right away. For example, your client may be facing a date rape type charge, and in those circumstances, there may be witnesses who have critical evidence to give, perhaps observations of the complainant and the accused immediately before or immediately after the alleged sexual assault. They may have seen flirtatiousness before, or they may have noticed a calm demeanor or an absence of complaint on the part of the complainant immediately after the alleged assault. And it's important that if there are witnesses of that type, that they be interviewed immediately, because they may be witnesses to facts that seem insignificant at the time. They don't appreciate the significance until they're interviewed. So it's important that you ascertain early on whether there are such witnesses, and if there are, that they be interviewed before their memories fade. Of course, once you get disclosure, you review disclosure, review it yourself, review it with your client, and you may, after reviewing the disclosure, see that there are other witnesses that have not been interviewed. They may be witnesses to relevant events. They may be witnesses who've had some conversation with the complainant, and the hope is that the complainant has given them an account that is different in some way than an account given to others, and that the inconsistencies can be exploited in attacking the credibility or reliability of the complainant at trial. So it's important to identify whether there are such witnesses and to have them interviewed early on.
Would you ever go to the Crown, to Paul McDermott here, and ask him to interview some witnesses for you?
Well, I think that's a mistake, generally
So do I.
speaking. I think that it's common for the defense to write an efficient letter early on in the case, listing all of the potential holes they see in the investigation or lack of corroboration of witnesses, and I think it's a real mistake to rely on the Crown or think that the Crown or the police are going to do anything about it at all. In many of these cases, the majority, I think, the Crown relies on the complainant's evidence and the complainant's version of events, and the police, even if the Crown were to instruct them to do so, won't do much else other than take the complainant's version of events and anything that, on the face of it, comes out of that version of events. And so, while the letter may be a good idea to organize things in your own mind, I wouldn't expect much to be done if it's said.
Well,
How much,
I'm sorry, Austin, but there's another problem from the defense perspective. I don't want the police going to interview witnesses that I'm interested in. First thing, the police may go and interview the witness, and it may turn out that the witness I've sent them to interview isn't helpful to my position at all. And secondly, perhaps cynically, even if the witness is helpful to the defense, I don't want the first interview done by a police officer who may put a prosecution spin on the interview.
okay. To what extent, Paul, do you feel under the gun as a result of the Stinchcombe case? I mean, suppose the charge is laid, a police investigation continues, other things are unearthed. Is it concern of Crown's that maybe they haven't made enough disclosure, or the police bring another piece of paper in that maybe reflects another aspect of the case that causes you a little chagrin? How much under the gun do you feel as a result of Stinchcombe?
Well, I think it's changed the role of the Crown in terms of disclosure a great deal, and it's placed an obligation on the Crown to do more than blithely accept what the police give them and assume that's the extent of the case. I think the Crown has to be, to some extent, an investigator to make sure that the defense has all of the disclosure, but not to investigate issues that the Crown feels may be a problem later if they're not investigated. They'll live with the consequences of that. But in the different issue of making sure all the disclosure's done, I think the Crown and Stinchcombe places a real obligation on the Crown to make sure that that is done. And it is a real difficulty because there are a lot of things the police don't give the Crown, and they have to start making sure that they have everything in the police file that the defense wants. The only caution I've given is the pretrial ruling in Moran. Justice Donnelly was distinguished between sort of a catchphrase request for everything in the police file and put some obligation on the defense to make specific requests about things, and not to, and a phrase such as everything in the police file relevant to this case may not come back to cover you if the Crown doesn't give you something. There's an obligation on the defense to be more specific than that. And now, the extent to which Justice Donnelly's decision is relied upon or carries weight, I don't know, Michelle, but I think there's danger in such a broad phrase.
How would you go about getting disclosure, Michelle, and particularly when it comes to such things as background history of the complainant, psychiatric records, and that sort of thing, sort of at the outset and before getting into a preliminary hearing?
That raises the whole issue of what is coming to be known as third-party disclosure, and that includes anything, as Mr. Cooper has mentioned, from psychiatric records through school records, Children's Aid Society records, physicians' records, counselors and therapists' records, etc. And I think that this is a potential quagmire for the defense, and perhaps not as useful an area as many of us have thought to this point. And the reason I feel that way is there was a decision from the British Columbia Court of Appeal earlier this year, O'Connor number 2, which is being applied by judges in Ontario and sets, I would suggest to you, a very high standard for defense counsel to meet in order to access third-party records concerning complainants. Essentially what the British Columbia Court of Appeal said in O'Connor is that there is a two-stage process. The defense must make application for the records, and at the first stage will be required to show that there is likely relevance of the records to an issue in the trial. Now, just pause for a moment and think about that. Remember that you're dealing with records that you as defense counsel have never seen. And somehow you have to be able to show that an unknown has likely relevance to an issue in the trial. I think that's an exceedingly high standard that we have to meet. Assuming you meet that standard, however, that's not the end of the matter, because then at the second stage, O'Connor says that at that point the trial judge should take a look at the records, him or herself, and release only those which are material, once again, to the issues in the trial, in the sense that the defense would be unable to make full answer in defense without them. So you now have the matter being turned over to the trial judge, and remember, this is a pretrial application. It's the outset of the proceedings. The trial judge doesn't really know what the case is all about and what the issues are, other than what he's been told by counsel or she's been told by counsel. But nonetheless, the trial judge is assigned the responsibility to now decide whether you will get anything, and if so, what you will get.
Maybe
So
we're a little ahead of each other, of ourselves. We're at sort of the initial Crown disclosure Stinchcombe stage.
Yeah, so what I was going to say is I think you have to bear that in mind when you're at the initial disclosure stage in deciding whether you want to take the next step and make a formal application for these records. And I think there are potentially some downside risks to doing it through this formal application process. One of them is that Crown attorneys are customarily telling complainants that they may have to get their own counsel. Legal Aid is funding counsel for complainants on these records applications. I have seen it had an impact in the sense that counsel for the complainant decides to continue to be involved in the case, becomes involved in preparing the complainant to testify, sitting in during the trial, assisting Crown counsel in questions for cross-examination, and so on. So that's one downside risk. The other downside risk is that if you decide to go ahead with a formal application, you're going to have to file affidavit material that discloses why you say these documents are relevant. And that, I think, really is giving Crown Counsel an unusual degree of access to not just the position or theory of the defense, but also as to your line of approach to the complainant. So I would be very cautious about trying to jump ahead at an early disclosure stage and start thinking about a formal application. There are some cases that say you can make these applications to a preliminary inquiry judge. I think you have to consider carefully whether you want to do that.
Suppose the Crown has some information. Suppose the complainant, now we're dealing with disclosure in advance of the preliminary inquiry. Suppose, Paul, the complainant has advised the police that she's been in psychiatric institutions and that she's accused other people of sexually molesting her before, and she's had breakdowns and all that sort of thing, and some of this stuff is turned over to you as the Crown. Do you have to turn that over to the defense?
I don't think so, not unless they ask.
Not unless they ask.
I don't think that I don't know what the defense is. I don't know whether there's an allegation that it was consensual or it didn't happen. It's a figment of her imagination. I think there's an obligation on the defense on material like that that's once removed from the complaint to request it. If they request it and I have the power to turn it over to these agencies, I'll turn it over, of course.
So I guess, Dave, rather than just a broad general letter, that's one of the specifics that you'd include in the letter. Do you have any prior history of mental illness or institutionalization of the complainant?
It's something I'll include in the letter now that I know what Paul's position is.
Okay. All right. Well, we've learned
previously,
something.
I wouldn't have thought of getting into that much detail, and frankly, I would have thought that maybe prior psychiatric institutionalization of a complainant is not necessarily, given when it occurred. It may have been a long time ago, or what it was for. It may not necessarily be relevant to the issues at trial. I would have thought that a prior false allegation of sexual assault is always relevant in a prosecution on sexual assault.
So you have the pressure on the prosecution to produce, and you have the need on the part of we defense counsel to ask and hopefully to get. Let's go a little further. Suppose, Dave, you decide that there are a number of witnesses that should be interviewed. How do you go, other than witnesses that have been provided to you by in the disclosure, how do you go about doing that? Do you go and knock on their doors yourself, or what's the best?
Well, I guess I first either myself or have someone contact the witness and ascertain whether the witness is prepared to be interviewed. My preference would be that the initial contact not be done by me, because if the witness doesn't want to be interviewed by the defense, I don't want there being any suggestion that I, in that initial contact, made any inappropriate attempt to influence the witness in what they would say. Once it's ascertained that witnesses are prepared to be interviewed, there are really two objectives that I have in mind. First, I want to know everything that the witness has to say, and secondly, I want to get a statement from the witness that will bind the witness to their story, so that if they try and come up with an inconsistent version at trial, they can be cross-examined on the inconsistencies. And there's a problem if I've interviewed the witness alone and the witness comes up with a new version favorable to the prosecution in his or her testimony. I'm in an embarrassing position, because all I can do is stand up and say, well, didn't you say something different to me when I interviewed you in the office? And if the witness says no, I got a choice. I can stick with the answer, which is not satisfactory, or I can take off my gown, pass it to some other lawyer, lose the case, and become a witness. Also not very satisfactory. So the obvious solution is to make sure that if you're interviewing witnesses, you have your own witness to the interview, either another lawyer, private investigator, an articling student. Or you may consider not becoming involved in the interview yourself at all, and having the interview conducted entirely by some other party, a
Michelle,
private investigator.
do you tape record interviews with witnesses?
Not ordinarily. However, if I'm interviewing a witness who I know is also on the Crown's list of people who have been contacted by the police, I do try to have a third person, somebody from my office, sit in so that there's never any question later about what was said and how certain information came into my hands.
And would that person take notes?
Yes.
All right. Would you try to get the witness to sign the statement?
Ordinarily, I don't know.
Is there a reason for that?
No particular reason. That just hasn't been my practice.
Okay. What about you, Dave? Would you have
My preference is to, if I'm concerned that the witness may become less friendly to me when the witness hits the box, I want to make sure I have a statement which is as detailed as possible and to which the witness will feel bound. And for that reason, I like a statement that is signed and initialed by the witness. And although it's not ordinarily done, I think tape recording the interview would be a good idea if the witness is prepared to be tape recorded. That gives you two things. It gives you a perfect record of what the witness said, so there can be no doubt when it comes time to cross-examine on a prior inconsistent statement. And if the witness attempts to suggest some improper influence on the part of the interviewer, some attempt to shape the witness's evidence, again, you've got a perfect record of what was said during the interview, and you can rebut the suggestion that inappropriate pressure was applied.
Well,
I
Michelle,
think if I can just interject, the only thing you have to be a little bit cautious about with tape recording is that, first of all, you need to make sure the witness knows that you're tape recording the interview, and that may cause some witnesses a certain amount of discomfort. And I think if you're trying to get the best version of events in the sense that you think the witness has information helpful to your client that may not have been disclosed to anybody else, it may just set a certain tone to the interview at the outset that you don't want.
I think that's fair. The comments I'm making are really focused primarily on cases where you suspect the witness may not be as friendly at trial.
when you talked about, Dave, about interviewing your client and getting some idea from your client as to what the defense is and so on, suppose his wife wants to come along, or he wants to bring his father into the interview. To help him along, is that something you encourage?
They can come, but they're going to sit in the waiting room.
And the reason is?
Well, the concern is twofold. The first concern is that if you have a third party sitting in on the interview, a parent or a spouse, the client may feel inhibited. The client may not be prepared to give you a full and frank account or a full and frank version of events. He may feel on some particular issue that to please the third party who's present, that he's going to take a position that may turn out to be either completely unreasonable or demonstrably false. And
To please his father, or
absolutely,
his wife,
or his wife, or
particularly in
whoever.
a sexual assault case.
Exactly.
What about the privilege issue?
Well, that's the other concern, that the presence of a third party generally compromises privilege. There's obviously privilege between conversations between solicitor and client in private, but if a third party is introduced into the conversation, then privilege is generally compromised and lost.
Do you think it's a good idea then? I mean, sometimes the wife doesn't want to leave, or the father doesn't want to leave, or could that be an excuse that you can provide, that privilege is destroyed if you stay in this room, and accordingly, if you want to protect your son or your husband, maybe it's best you leave?
Well, I think in those circumstances where it appears that this third party wants to stay in the room and the client may be reluctant to request that they leave, I think it's the responsibility of the lawyer to make it plain that there is no choice in the matter, that privilege will be lost, and it's at the request of the lawyer. In fact, it's demanded by counsel that the interview with the client be conducted in private.
Michelle, suppose after getting disclosure, or some of the disclosure, and after talking to your client, it looks like she's, it would be a he, there aren't very many she's charged with sexual assault, and I hope I'm being politically correct. But suppose he's bang up, and it looks like you can't win the case, and he's going to be found guilty. To what extent do you consider entering a plea of guilty, perhaps in the provincial court as opposed to in some other court?
I think we all have to bear in mind what the Supreme Court of Canada has told us in Profit, which is that most clients charged with these kinds of offenses come from good backgrounds, have not previously been involved with the criminal justice system, and that as a result, that factor is entitled to minimal weight. That's true, I think, not just with respect to the issue of character during the trial, but also with respect to mitigating factors on sentencing. We also all realize that the tariff for these offenses in Ontario is high and seems constantly to be moving higher. So I think that an early guilty plea in a case where, as Mr. Cooper has said, the evidence clearly indicates the client's guilt is something that has to be discussed with the client before the preliminary inquiry. To give you an example, I was involved in one matter where quite a serious series of sexual assaults where prior to the preliminary inquiry, the client was offered 8 to 10 years on a guilty plea if he entered that plea or those pleas without a preliminary inquiry and before a provincial court judge. The client didn't want to do that, ultimately changed his mind partway through a lengthy preliminary inquiry. The provincial court judge sentenced him to more than twice that period of time and set the increased parole eligibility period, which he may or may not have been entitled to do under the new legislation. So I think there is a substantial downside risk in these cases if you have a client who is going to be pleading guilty to not doing it before the preliminary inquiry. As soon as the complainant or complainants take the witness box and are, from the judge's point of view, forced to give evidence about unpleasant circumstances, your client is going to be penalized in terms of the ultimate sentence, even if a guilty plea is entered partway through that proceeding. Now, whether to plead in provincial court or in general division may be a matter of personal choice. I think you have to bear in mind these days that, especially with the investment strategy, many Crown Counsel are prepared to give accused significant reductions for pleading guilty early on and for doing it in provincial court and for not forcing another file to go up to general division, even if you do waive the preliminary hearing. So bear that in mind. And obviously, you also want to make sure that you have a proper knowledge base about the various judges before whom the plea may be entered. And again, it may be that you're in front of an excellent judge at the provincial court level. You don't want to take the risk of a wild card. You don't know who you might get in general division. Conversely, you may be in front of somebody in the provincial court who you feel is known for giving high sentences, even on pleas to sexual offenses. And in that scenario, you may well decide to simply waive a preliminary inquiry and indicate to the Crown that your intention is that the client will plead guilty in general division and to do it there.
Paul, what's the attitude of the Crown Attorney to approaches early in the game as to pleas of guilty in sexual assault cases?
Well, I think there are two issues, Austin. One is that the pleas very rarely occur in these cases, and quite frankly, you almost never see pleas in sexual assault cases. So I think that makes it more disarming to the Crown on sentence when a plea does occur. And I think that the normal reduction for a guilty plea in a criminal case is strengthened in a sexual assault case because of the fact that they rarely occur. And it shows real remorse if the accused pleads guilty. And I think that it takes a very strong weapon out of the Crown's hands on sentencing. The other aspect, I know David takes this position in many cases, and I think in this sort of scenario it's a good idea, is that I'm not sure how important it is what the Crown's position is in a lot of these cases if your client is going to plead guilty, because I think it's an impressive point to be made if you said my client's pleading guilty here and I don't care if the Crown asks for 8 years. It's always nice to limit the Crown, but in some cases you can't because, as Michelle says, the tariff's high. And I think it makes the Crown look unreasonable if sometimes you can say, I didn't even approach the Crown, my client's pleading guilty. And particularly if there's been some work done prior to the plea in the provincial court or in the general division, some sort of psychiatric report or a pre-sentence report of some kind.
Of course, it could reflect remorse, couldn't it? Early plea of guilty, acceptance of responsibility for what the client acknowledges he did, and that's sort of thing courts and crowns, I guess, and complainants are happy to see.
I think
reflected in sentence.
I think you'd find the law, the sentencing law, really reflects a huge tariff reduction for a guilty plea as well, simply because most of the sentencing cases in the Court of Appeal don't reflect a guilty plea. And almost none of those cases you'll see in the report indeed he pleaded guilty. So I think you can use those as a standard to say it should be much lower than that because of the plea.
Well, Dave, do you think it generally pays, you know, even if the case looks pretty strong against the client, to say, well, we'll have a preliminary hearing, we'll see how the complainant does. It's a free ride, and I perhaps won't lose too much and maybe gain a little bit, and you never can tell what would happen. Is it kind of a free ride at a preliminary hearing? Or?
It's not a free ride. There's no question. I mean, I would simply echo what Michelle has already said, that that if it's a case where the client is inescapably caught and is prepared to plead guilty, then it's wise to plead guilty either before the prelim or waive the prelim, and then take the matter to the general division for a plea. And the reason is the plea, as you've noted, Austin, entitles the accused to mitigation for expressing remorse and accepting responsibility. But in a sexual assault case, there is particular and considerable consideration given to an accused who saves the complainant, the trauma associated with having to recount very embarrassing, intimate, and traumatic events publicly in court. So I think one has to recognize in a case of this type that generally, if you're having a prelim, there should be reason for it, and it means that you're in all likelihood going on to have a trial, because it's not a free step, and the needle on the sentencing meter takes a significant jump when you have your prelim and you make the complainant testify.
Suppose, and Michelle has adverted to this, if there's a question of a plea of guilty, perhaps if you like the provincial court judge and is not known to be a heavy sentencer, you go that way. If not, you can waive the preliminary hearing if it's going to be a plea of guilty, and the Crown knows it's going to be a plea of guilty, and then you have perhaps a choice of judges in the general division. Do you also have another type of choice in the general division, assuming you want to waive the preliminary hearing? What about pretrials? Does it give you access to different judges via the pretrial system?
Well, I think one thing it does, if perhaps you're trying to get the Crown to come down in his or her figures, often a pretrial conference will enable you to get the judge's view. It may persuade the Crown that perhaps they're asking for something a little high. Conversely, if your client essentially has indicated that he or she wants to plead guilty, but thinks that you should be able to get something like a suspended sentence, and you've had difficulty convincing him or her that that's going to be the case, after the pretrial, you can at least go back to the client and say, well, look, Judge X, having heard about all of your circumstances and the circumstances of the complainant in the case, has indicated that he or she feels a sentence would fall within this range. So it sometimes helps you to get the client to understand what the realities are.
What about Paul? You've been involved in a number of these things. Suppose the preliminary hearing has been waived. You know the client wants to, that the accused wants to plead guilty. You have your own idea of a range. Have you ever been involved in more than one pretrial at the general division level?
Yes, I have. Generally speaking, the pretrials are continued in front of the same justice. And if you don't get the right answer, or it's a little unsatisfactory in front of one justice, it's almost impossible to get a pretrial before another judge. I think that that is overt judge shopping, whereas there's a little bit easier way to judge shop in the general division, bouncing around practice court in different courts. But I think it's just a little too overt trying to get different pretrials. I think you continue the pretrial in front of the same justice, and if you don't like what that justice says, then you plead in front of another justice.
Well, if you don't like it, can the justice, and this is perhaps pretty elementary, but can the justice at the pretrial be the trial judge?
On consent, I think he can, or she can, and I think that on consent, the justice can entertain the plea as well. But I think the difficulty that some counsel are running into is that if a justice expresses a view as to what the sentence is in the pretrial and the Crown doesn't like it, then I think recently after the Martin Committee in a case in the Court of Appeal called Benolo, I think it is.
Benlolo.
The Crown can walk away as well, and I think the Crown's doing that with greater frequency now. So
Wasn't the Crown always able to say, well, I don't want to plead before this judge, I don't consent? We've bared our souls before you, and I'm not agreeing to have this plea before you.
Well, I think the Crown's always been able to do that. It's just that whether they have the temerity to do it sometimes is a different question.
Fair enough.
And I think that they have the law now and the Martin Committee on their side, and they're doing it with greater frequency. So I think that some of the defense counsel go just to the brink and find out what the justice is feeling and what they're saying without actually saying what the sentence is, and then they'll plead in front of that justice. But if a number's heard, then I think sometimes you open yourself up to the Crown walking away from that justice.
Well, actually, the law, as I understand it, coming from the Benlolo case and from the recommendations of the Martin Committee, are that even if the judge at the pretrial does not declare a position with respect to a specific sentence that would be imposed, if for whatever reason either side does not want the plea to be entered before the pretrial judge, then the pretrial judge ought not to take the plea. And you should bear that in mind. So, for example, if you're at the General Division and you're coming up for a pretrial before Justice Wren in a case where you know you're going to be entering a plea, don't bother with the pretrial. Just say, thanks, Your Honor, we'll see you in court and we'll enter the plea, because if you have a pretrial, you risk the Crown saying that they're not prepared to have Justice Wren take the plea.
Well, suppose, let's get to the situation where you haven't determined that your client should plead guilty, or he doesn't want to plead guilty, and there's got to be a preliminary inquiry. How are you going to elect to be tried, by judge and jury or judge alone? And perhaps even before getting to that, what are the time limits that govern there? Suppose you come to the preliminary inquiry. Dave, or perhaps I'll ask you, Michelle, how would you elect originally, and what sort of protection would you try to get for yourself if things don't go so well at the preliminary hearing, or if perhaps 6 or 8 months down the line you learn some new things that make you decide that you don't want to proceed with the mode of trial that you originally elected?
I guess those of us who practice in Toronto sometimes get a little bit lax on this issue because we're used to the Crown's agreeing to a re-election to judge alone on the day of trial. But what I normally do is elect judge and jury, and especially if I'm in a jurisdiction outside of Toronto, I speak to the Crown at the preliminary inquiry and get an agreement that a re-election would be permitted up to a certain point. Quite often that point is the date of the pretrial conference in General Division. Sometimes it's something else, again, depending upon how the individual jurisdictions schedule their trials. I then usually will follow up with a letter to the Crown confirming that this is our agreement, just because it avoids misunderstanding if, for example, the brief gets passed on from one Crown to another. So I elect judge and jury initially, but try to keep my option open to re-elect at least as of the date of the pretrial conference in General Division.
The criminal code, which you've helped write, provides for a time limit, which is 2 weeks after the end of the preliminary hearing.
Which again is a reason why I think you're wise to speak to the Crown at the time of the preliminary inquiry to make sure that you're not going to be held to that strict time limit.
How do you feel about permitting re-elections, Paul, up to the point of a pre-trial or up to the day of the trial? Suppose there's been an election at the preliminary hearing for judge and jury. Are you generally happy to consent, and you can always consent, of course, as I understand the law, to a re-election for judge alone on the day of trial?
Well, it depends on the nature of the case, and I think the jurisdictions, to some extent, I think, as Michelle pointed out, in Toronto, we are generally allow re-elections in most cases in the General Division, even on the morning of trial. But it's a perilous situation unless you do something like Michelle offers, and that is to firm it up in writing. I think that in many situations you're likely to get as an oblique a letter, as my answer hopefully is, about about whether or not we're going to consent, because as we don't have to after the 15-day period, and we don't have to give reasons, as I understand it, and the Crown may or may not, depending on the type of the case. In Toronto, I think you'll find in most situations the Crown will allow a re-election. I understand it's not like that in other metropolitan jurisdictions around Toronto, but it is that way in most cases in Toronto, and but you're always subject to it not being that case in a
Outside of
particular
Toronto.
situation.
So I guess the clue to distill out of that, try to protect yourself at the outset of the preliminary inquiry by getting some sort of a commitment from the Crown Attorney, and then if you get one, write to the Crown confirming that. Okay. Well, how do you feel, Dave? These are sexual assault cases. Generally, you like to have them tried by judge and jury, or judge alone once you get up beyond a preliminary inquiry? How do you elect in these cases, or can you generalize?
Well, I'm not sure that you can generalize. My preference seems to be in cases like this that I prefer judge alone. If I have a good defense, if I have a viable defense that I think will persuade a reasonable person analyzing the Crown's case critically and fully appreciating the onus on the Crown to prove its case beyond a reasonable doubt, my preference is to go with a judge sitting without a jury.
I'm just stopping you there for a moment. Michelle, do you generally like juries for sexual assault cases?
Well, after hearing Paul in our discussion before the panel say that he always prefers it when the defense elects to have a jury, I think I'm with David on this issue, especially if it's a case involving child complainants. My personal sense is that juries tend to be more accepting of the fact that there will be frailties in their evidence than our trial judges, and particularly for that category of cases, I prefer to have a judge alone.
Paul, is it fair to ask you as a Crown Attorney, and you don't have to incriminate yourself?
I don't remember saying that to Michelle.
I do.
I'll send you a letter confirming it.
I mean, you're a prosecutor. The Crown never wins and the Crown never loses, but do you generally prefer to prosecute these cases before juries or judges alone?
Oh, I really couldn't say. The Crown's
All
not
right.
interested in obtaining a
We'll leave it right
conviction.
there. Okay. Let me say this, if the moderator can get involved in the fray. Generally, I prefer juries with sexual assault cases. Now, I'm not talking about sexual assaults involving children, but my experience is that juries, balanced juries of males and females, generally deal in a pretty balanced way with sexual assault cases. But I guess each person must draw on his own experience in these matters. If I get badly burned, I may swing with Dave's view.
Well, except I agree with the comment you made, Austin. It really depends on the nature of the case. As I hear what you said, is if it's a case involving an allegation made by a young child, you might abandon your preference for a jury and go with a judge alone. I would agree with that. If it's a case, for example, where the issue is ID, I have a strong preference for trial by judge alone in an identification case. Judges have been brought up, have been educated regarding the frailties of identification evidence, and they will carefully analyze the evidence of a complainant if identification is the issue, whereas my concern would be that a jury might be overwhelmed by the sincerity of an honest but mistaken complainant in a sexual assault case when she makes identification of the accused. So that's the type of case where, again, I favor judge alone over judge and jury. Conversely, there may be cases where there's evidence that the Crown will try and put in that's quite prejudicial, either in the form of a confession or similar act evidence, that might come before the judge but might be ruled inadmissible by the judge.
But he will have heard it.
He would have heard it. And in a case like that, although the judge, having ruled the evidence inadmissible, is not to give it any consideration subconsciously, there's a concern that he or she might. So in a case like that, if I think that the confession or similar act evidence is likely to be ruled inadmissible, I'm much more likely to take a jury. And I must say, Austin, just finally, that when I have a really, really difficult case, I always take a jury.
What about, Paul, we're dealing with election and mode of election. Let's deal with the preliminary inquiry. You as a Crown, you got a sexual assault case. Do you like to call all the witnesses so you get an idea as to not only how the complainant looks, but how all the other supporting witnesses look? Or is it your general practice just to call the complainant, get yourself over the Shepherd line, Shepherd in USA, and leave it at that?
I almost always just call the complainant on a sexual assault case. I think that it's the best thing for a Crown. I don't think from the Crown's perspective much is gained by calling the other witnesses. Some Crowns feel that certainty is gathered to your case for trial by calling other witnesses. I don't feel that way. Once the complaint...
Don't you feel badly, though, that you've...
No, even when I'm approached with sentiments like that, I don't feel badly.
This man has no conscience.
And,
well, all right, we've heard what he'll do. Michelle, facing a fellow like Paul, a man without a conscience, what do you do when you realize that the only witness you've talked to, he's only going to call the complainant? How do you protect your client at the preliminary inquiry? Because do you want to hear some of the other witnesses, and how do you go about getting them?
Almost always I want to hear other witnesses. Certainly, for example, if it's a matter within the family, other family members, for example, who have been interviewed by the police, the child's mother, for example, or if it's a complainant who's somewhat older, usually there are going to be witnesses interviewed by the police who will say, oh yes, she told me such and such had happened several years ago. That evidence may not be admissible at trial, but on the other hand, I think you have to hear it to make sure you know what's lurking out there in the event that you're going to be alleging recent fabrication. So what I normally would do is try to contact Paul in advance, and assuming he'll take my call, to ask him if he would make the other witnesses in the brief available, or at least those particular ones that I certainly want to hear from. Ask him if he'll make them available at the time of the preliminary inquiry, at least for me to call as my witnesses, but preferably just put them up for the purpose of being cross-examined by me. And I found that most Crowns are agreeable to doing one or the other if you notify them in advance. On the other hand, if you show up on the morning of the preliminary inquiry and say, well, but what about witnesses X, Y, and Z, why aren't they here? You're going to have a difficult road to hoe to convince the Crown that at that point police officers should run out and start trying to collect up these witnesses, and most provincial court judges are not going to give you an adjournment on the basis that you just this morning had alerted the Crown to the fact that you wanted them there.
Paul, if you're asked by Michelle or by Dave to bring witnesses X, Y, and Z to the preliminary hearing, have the police subpoena them or phone them and have them available, will you generally arrange to do that, A? And B, will you put them in the box and ask their name and address and where they went to school, and allow the defense to cross-examine them?
I'll, the first part I'd agree to, because the police normally subpoena everyone in the Crown brief for the preliminary inquiry. And if Michelle or David called me and said, are these people under subpoena, and asked that I ensure through the police that some witnesses are going to be there, I'll do that. I won't call a person and ask them their name and address and allow the defense to cross-examine them. If the defense wants to call a witness at the preliminary inquiry and examine them in chief, according to the rules of evidence that govern, then I'll sit there and make sure they don't cross-examine and they examine in chief. That's my practice.
Okay, and I guess...
See if I ever take you golfing again.
Well, let's deal, because we're running out of time. What about the complainant? We're at least going to have the complainant, whether the Crown Attorney has a conscience or not. He's going to call the complainant. Dave, would you go after the complainant with a full blast cross-examination as you would before a jury, or would you cross-examine her in a very limited way for some tactical reasons?
My general approach is that if I'm going to cross-examine the complainant at the preliminary inquiry, it means that I'm going to be going to trial, and I'm going to be cross-examining the complainant at trial. And if that's the case, I generally go full bore. I ask all the questions of the witness that I would at trial. I make all the suggestions to the witness that I would at trial, because I want to know what the answers to all those questions and all those suggestions are.
Aren't you worried that the complainant will become accustomed to your style of cross-examination and be a little less vulnerable the second time around at trial?
Well, I guess there's always that risk. There's the risk that the complainant will learn from the experience of the preliminary inquiry and may try and shape either their demeanor in the box or their evidence at trial. But the beauty is you've got the transcript of the preliminary inquiry, and any attempt by the witness to change his or her position at trial can be answered by vigorous cross-examination on the transcript, and the suggestion that the reason they're changing is because they've now had time to think about the questions and suggestions put to them at trial, and they're now changing their position.
How about you,
and they've had time to
Michelle?
concoct
Do you
it.
go full bore at a complainant at a preliminary hearing, or would you be a little more conservative?
Probably somewhere in between, in the sense that I try to ask the complainant the questions that may elicit answers that are damaging to my case, but that I feel I nonetheless need to know so that I can prepare for trial. And an example is, well, the line about why didn't you tell somebody sooner, why didn't you talk to your mother, your aunt, whoever. I think you need to know what the complainant's answer is going to be rather than leaving that hanging before you go to trial. So I agree with David that you have to ask the questions that will get you the bad answers sometimes just for the purpose of your future preparation. Where I tend to draw the line is at things like information I may have from other sources about about bad acts on the complainant's part. For example, if I have a complainant who has a history of dishonesty, of lying, of cheating, and so on, I won't necessarily put those allegations to him or her at the preliminary inquiry because I know I can make an argument that that's not a collateral matter, and I can always contradict him or her at trial with my witnesses if I have to.
Prior disreputable conduct, that sort of thing,
Yes.
going to credibility. Right. What about the question of Regina and Kuhn? We talked earlier about prior psychiatric records and institutional records and so on of a complainant. How do you go about at a preliminary hearing, or do you go about at a preliminary hearing, structuring a future application for production of those records which may not be in Paul's possession or in the Crown's possession? What do you do about that at the preliminary hearing, Michelle?
I think you have to get, or at least try to get, the information at the preliminary hearing about, for example, who has the complainant seen for counseling, therapy, medical assistance, whatever the case may be. Have there been dealings with the Children's Aid Society previously? Generally, that information is not going to be contained in the Crown brief, and as Paul has told you, he's not going to go out looking for it or asking the police to look for it. So I think your only avenue for discovery, if you like, of that information is by asking the complainant to give you that information at the preliminary inquiry. Without it, you're not going to know where to go to get the records that you need for a third-party disclosure application.
And having regard to the decision of the British Columbia Court of Appeal, aren't you going to have to be able to establish some way at the preliminary hearing prima facie relevance to some of these institutional records and so on? And are you going to be able to get that at the preliminary hearing?
There are some decisions. There's one from Justice Ferguson in Durham Region, for example. There's another by Judge Shamai in Brampton that indicate that you can make a third-party disclosure application at the preliminary inquiry. I think the practical problem is you're not going to have the foundational knowledge you need to bring that application as of the point when you start.
Perhaps I didn't make my question clear. Would you direct questions then at the complainant at the preliminary inquiry with a view to getting the foundational
Yes.
knowledge to get you over the first hump?
Yes. Who have
Right.
you seen? When did you see the person? Did you discuss the allegations that you've told us about in court with him or her and so on?
What's your reaction to questions to a complainant about prior institutionalization and Paul and prior psychiatric history and psychiatric records, setting up the Regina and Kuhn application at the preliminary inquiry? Do you as a Crown take a position on that, as to whether those questions are relevant at a preliminary inquiry?
Well, it really depends on the case specific. I don't think as a general rule the question is always relevant, and I'll object in some situations, but I have a certain amount of sympathy for it being the only avenue for that issue to be determined. The complainant may be the only person with that information, not having told the police or the Crown, and so I do have a certain amount of sympathy, and I wouldn't object to a lot of questions in that area. I should perhaps correct one thing. that David said earlier, if there's a prior allegation of a false complaint in the Crown's knowledge, it definitely disclose that right away. I thought the question or the issue was if there's a prior complaint. I mean, if it had been determined to be false, then I think it's always relevant. But if there's some complaint that was never proceeded with, or something else happened to it, I don't think that's always relevant and must be disclosed unless the defense asks. But I think if there's any evidence that the complainant has falsely complained of sexual abuse by someone, I think that's always relevant. And if I had that information, I'd disclose it immediately.
I'm sorry, just if I can follow up on that. So our letter requesting further disclosure from you, Paul, should include a reference to any prior allegations of sexual assault or sexual abuse.
Yeah.
Well, suppose the complainant's made a prior allegation of... Oh, I see. I'm told that we're running short of time. We've got Mr. Executioner over here has said that we can't proceed much further. And so I hope that this has been of value to you. We've only had 50 minutes, but we've tried to provide some clues as to some of the issues that may confront defense counsel in assessing the case from the beginning, investigating the case, getting disclosure, making determinations about when and where to plead guilty, and how to conduct a preliminary inquiry, and how to elect and preserve the right to re-election. I hope it's been of assistance. Thank you.
Good morning. It's my privilege this morning to introduce Brian Greenspan. Brian's going to be speaking to us on hearsay this morning. Mr. Greenspan is a partner with Greenspan and Humphrey, David Humphrey being his partner, who was on the last panel. He has been a certified specialist with the Law Society in criminal law since 1974. And he sits actively and takes a leadership role in a number of organizations that are concerned about how criminal law is advancing and are concerned with education as far as criminal law is concerned. Some of the groups that he's involved with, for example, are the Canadian Council of Criminal Defense Lawyers, the Criminal Lawyers Association, the Criminal Justice Section of the Canadian Bar Association, Society for the Reform of Criminal Law, and the Advocates Society. We're privileged this morning to have him here to speak on hearsay.
Thank you. First, I was going to ask Austin to stay on to simply ask me questions, which perhaps might expedite this. But let me introduce what is now, I think, a very troubling topic in the criminal law, and one that's in the midst of tremendous change and upheaval, by making perhaps brief reference to the rule against hearsay. Essentially, and as we all grew up with it, it was referred to as one of the oldest, most complex, and most confusing of the exclusionary rules of evidence, and hence one of the more difficult to accurately define. Obviously, in that observation lies an enormous criticism of the rule, yet when one looked to the definitions, it always seemed to many of us that the definition itself was reasonably clear-cut and one which was reasonably definable. In fact, in Sapinka, Letterman, and Bryant, quite unexceptionally, they define it as written or oral statements or communicative conduct made by persons otherwise than in testimony at the proceeding in which it is offered, and that evidence is inadmissible if such statements or conduct are tendered either as proof of their truth or as proof of the assertions implicit therein. Although it may be criticized, it seemed to be rather clear-cut in terms of what wasn't permissible, what wasn't admissible, because the rule was designed to guard against potential danger that the traditional safeguards of cross-examination of the declarant or observations of the declarant's demeanor would not be able to be assessed in an effort to assess the trustworthiness of the statement. So in circumstances where those safeguards were absent, the evidence was, at least on its face, excluded. Now, the exclusionary rule was subject to both exceptions and criticisms, and the exceptions, depending on which text you look at, range anywhere from 13 to 23, depending on how those exceptions were defined, whether one exception included 3 exceptions, and the various types of applications of those exceptions. The exceptions are not the subject matter of our discussion today. The criticisms perhaps are, because the criticisms really began with describing the traditional rule as the inflexible approach, the category approach. Well, the inflexible approach in itself creates the criticism simply by labeling it inflexible. And the criticisms have now been manifested in what has been heralded, at least by the Supreme Court of Canada itself, as, and I quote from Chief Justice Lemaire and Smith, as the triumph of a principled analysis over a set of ossified, judicially created categories. Well, the triumph of a principled approach. First of all, let me observe this, that statement by the Chief Justice might be classified as the triumph of the public relations approach to judicial pronouncements. The principled approach, if you take a look at what principled means, must mean as follows: that the principled approach is imbued with or having principles. A principle is a general and fundamental truth to be used in deciding conduct or choice. A fundamental, primary, or general law or truth from which other truths are derived. And perhaps equally applicable, a guiding sense of the requirements and obligations of right conduct. Well, that's what we have in the triumph of the principled approach. And obviously, it seems that the Chief Justice and the court must have consulted a public relations firm, because obviously anyone that disagrees with the two-pronged test of necessity and reliability and the triumph of the principled analysis must be using an unprincipled analysis to criticize this new world. Well, how did we get to this new world of necessity and reliability in such short order? The rule had survived its numerous attacks for more than a century, and the Supreme Court of Canada almost seems as, during a 2 to 3 year period, as if it didn't reinvent the wheel, they think they invented the wheel. And to some extent, I would suggest that they may have discovered fire. There's the trilogy, and the trilogy forms the foundation of what we now have as the new rule, and the rejection of the inflexible categorical approach, the acceptance of the principled analysis. It begins with Kahn, it goes to Smith, and it then goes to KGB. The engine which drove this reanalysis and this change, and I suggest at the outset, and please understand, I accept that this is the world we must now live in terms of the approach to hearsay, and I have my criticisms of the principled analysis, but the principled analysis begins, and the engine which really propels it is, in my submission to you, a policy rather than a principled approach to the rule against hearsay. And the policy analysis is fundamental to the direction that the court took, and the policy analysis is clearly manifested in the Kahn case. This engine, having regard to the subject matter in Kahn, perhaps is the little engine that could. The Kahn case is the first and most fundamental of the cases, and it's only now 4 years old. September 13th of 1990. It should be noted it's only a panel consisting of 5 members of the court, only 4 of whom are currently on the court. The Chief Justice had become Chief Justice prior to the rendering of the judgment and sat as Chief Justice when the judgment was released. Justice Wilson, Justice Sapinka, Justice Gontier, Justice McLaughlin, who wrote the judgment. I'm sure most of you are familiar with the facts behind Kahn, but let me very, very briefly review Justice McLaughlin's judgment, at least the critical portions of it. Recall that this related to Dr. Kahn, and at page 99 of the judgment of the Supreme Court of Canada, Justice McLaughlin observes that 15 minutes after leaving Dr. Kahn's office, in response to her mother's query, "So you were talking to Dr. Kahn, were you?" T told her mother about the sexual act the doctor had performed on her. The issue is whether the mother's statement of what she was told is admissible in evidence. The trial judge rejected the statement, holding that it was hearsay and did not fall within any of the established exceptions to the hearsay rule, and in particular, the spontaneous declaration exception. The Court of Appeal held that the statement should have been received on the ground that the inherent reliability of the child's statement was such that the usual requirements for spontaneous declarations of contemporaneous and intensity or pressure should be relaxed. Justice McLaughlin then says, "I'm satisfied that applying the traditional test for spontaneous declarations, the trial judge correctly rejected the mother's statement." So, at the outset, it's a rejection of the position of the Court of Appeal, and we should remember this because other courts and other judges have gone back to some of the underlying positions adopted in the Court of Appeal to justify the de facto application of Kahn in the Supreme Court of Canada. But McLaughlin rejects the analysis in the Court of Appeal for Ontario, rejects the fact that it could be part of an extension of spontaneous declarations. The statement was not contemporaneous, being made 15 minutes after leaving the doctor's office and probably 1/2 hour after the offense was committed. Nor was it made under pressure or emotional intensity, which would give the guarantee of reliability upon which the spontaneous declaration rule has traditionally rested. Now, let's stop for a moment. Part of the rule always, to all of the exceptions, underlying every exception, every category of exceptions to the hearsay rule, was reliability. So at one time, McLaughlin rejects that reliability had been established in the context of the traditional exception. But that's not the end of the inquiry. The question then is, to the extent to which, if at all, the strictures of the hearsay rule should be relaxed in the case of children's testimony. The issue is one of great importance in view of the increasing number of prosecutions for sexual offenses against children and the hardships that often attend requiring children to retell and relive the frequently traumatic events surrounding the episode in a long series of encounters with parents, social workers, police, and finally different levels of courts. The hearsay rule has traditionally been regarded as an absolute rule. subject to various categories of exceptions such as admissions, dying declarations, declarations against interest, and spontaneous declarations. While this approach has provided a degree of certainty to the law on hearsay, it has frequently proved unduly inflexible in dealing with new situations and new needs in the law. This has resulted in courts in recent years, on occasion, adopting a more flexible approach rooted in the principle and the policy underlying the hearsay rule rather than the strictures of traditional exceptions. Well, with great respect, that turns the traditional exceptions perhaps upside down and inside out, because the traditional exceptions, as analyzed in Wigmore and every other appropriate analysis, depends upon the principles of necessity and reliability. That's their roots. The roots of the exceptions are in the certainty that's created by categories, but the certainty that's rooted in the principle of necessity and reliability. So what we have here is a rejection of the notion that first of all, there was evidence to support reliability in the context of the traditional exception. We then move on to the notion of there ought to be a policy that addresses the problem that's created by the evidence of children. And that, with respect, I suggest, is a policy position and a policy attitude toward the problem. After looking at Aries and Venner and looking at some of the traditional formulations of the hearsay rule, Justice McLaughlin, after referring to Lord Pierce's tests in Myers, says as follows: Lord Pierce's 4 tests may be resumed in 2 general requirements: necessity and reliability. The child's statement to the mother in this case meets both these general requirements as well as the more specific tests. Necessity was present, other evidence of the event, as the trial judge found, being inadmissible. The situation was one where, to borrow Lord Pierce's phrase, it was difficult to obtain other evidence. The evidence also bore strong indicia of reliability. T was disinterested in the sense that her declaration was not made in favor of her interest. She made the declaration before any suggestion of litigation. And beyond doubt, she possessed peculiar means of knowledge of the event of which she told her mother. That assumes that it was true, by the way, but nevertheless, that's the statement made. Moreover, the evidence of a child of tender years on such matters may bear its own special stamp of reliability. As Mr. Justice Robbins stated in the Court of Appeal, and here is perhaps a problematic statement that is repeated in other judgments. Justice Robbins in the Court of Appeal in Conn said as follows: where the declarant is a child of tender years and the alleged event involves a sexual offense, special considerations come into play in determining the admissibility of the child's statement. This is so because young children of the age with which we are concerned here are generally not adept at reasoned reflection or at fabricating tales of sexual perversion. They manifestly are unlikely to use their reflective powers to concoct a deliberate untruth, and particularly one about a sexual act which in all probability is beyond their ken. The court then goes on to say as follows: because of the frequent difficulty of obtaining other evidence, because of the lack of reason to doubt many statements children make on sexual abuse to others, courts in the United States have moved toward relaxing the requirements of admissibility for such statements. It's based on this general proposition that Robbins very, very clearly, very, very concisely summarizes in that brief paragraph. There is a sense of common sense to that. There is a sense that for all of us that have children, or all of us that have observed children, generally we find it difficult to think within our own experiences that children could conjure up fabricated details of sexual perversion, as Robbins states it. Is there a scientific foundation for that conclusion? A very speculative one. Is there a clinical foundation for that conclusion? Certainly one that wouldn't pass the ladder test in Mohan as being one which has at least a level of scientific reliability that would permit an expert to testify to what Justice Robbins seems to embrace and accept without exception. So one of the problems underlying this policy change and the underlying reason for the policy change and the underlying perhaps intrusion into the categorization of hearsay exceptions lies in this almost self-evident assumption that children are unlikely to fabricate stories of sexual intrusiveness. The Supreme Court of Canada goes on and states that these developments in the United States, the developments of what we know about children, these developments underline the need for increased flexibility in the interpretation of the hearsay rule to permit the admission and evidence of statements made by children to others about sexual abuse. Insofar as they are tied to the exception to the hearsay rule of spontaneous declarations, however, they suffer from certain defects, namely that they won't be admissible. The analysis then goes on, and in short order, we get to the bottom line after a review of what's been happening in Canada. The first question should be whether reception of the hearsay statement is necessary. Necessity for these purposes must be interpreted as reasonably necessary. The inadmissibility of the child's evidence might be one basis for a finding of necessity. So the inadmissibility of the child's evidence might be one basis for a finding of necessity. But sound evidence based on psychological assessments that testimony in court might be traumatic for the child or harm the child might also serve. So we either have a situation where the child is unable to recount, unable to relate, or even expert evidence that although the child may be able to provide the details and may be able to testify, it would cause a traumatic effect on the child. So all of these considerations would yield or at least satisfy the requirement of necessity, because that would mean that the child would be unavailable and therefore couldn't testify firsthand. Justice McLaughlin says there may be other examples of circumstances which could establish the requirement of necessity. The next question should be whether the evidence is reliable. Many considerations, such as timing, demeanor, the personality of the child, the intelligence and understanding of the child, and the absence of any reason to expect fabrication in the statement may be relevant on the issue of reliability. I would not wish to draw up a strict list of considerations for reliability, nor to suggest that certain categories of evidence, for example, the evidence of young children on sexual encounters, should be always regarded as reliable. The matters relevant to reliability will vary with the child and with the circumstances, and are best left to the trial judge. Which also means best left to the trial judge means that in any given case, one will never know until the trial judge applies the individual discretion and judicial reasoning which may come to bear in a case, whether or not you're facing an admissible or inadmissible statement. So one thing that's clear about Con is that we're now into an area of discretion, we're now into an area of uncertainty, and at least, although the inflexible approach of yesteryear may have been unprincipled, it created at least some sense of predictability. What is also clear about the principled approach is it creates a sense of uncertainty as you approach the task of preparing for trial. Finally, Justice McLaughlin, on behalf of the 5-member court, states, I conclude that hearsay evidence of a child's statement on crimes committed against the child should be received, provided that the guarantees of necessity and reliability are met, subject to such safeguards as the judge may consider necessary, and subject always to considerations affecting the weight that should be accorded to such evidence. This does not make out-of-court statements by children generally admissible. In particular, the requirement of necessity will probably mean that in most cases, children will still be called to give viva voce evidence. And that's a part of this judgment that's been almost universally forgotten in trial courts across this country. Now, I said that was September 13th, 1990. There have been many cases, both reported and unreported, which have applied the principles of Kahn in the real sense of the trial world, and have, I won't say for a moment, have universally found the evidence to be admissible and satisfying the tests of reliability and necessity, but I think that all of our collective experience would dictate that in large measure, and in most cases, with very little perhaps supportive or confirmatory evidence, generally speaking, if the child is young enough, the child is unlikely to testify, and if there is some form of so-called reliable hearsay, it's likely to be admitted. Perhaps one of the interesting early examples, and perhaps my attitude toward this, which seems to be already patently obvious to most of you, perhaps emerges rather clearly in one of the early applications of Kahn in a British Columbia trial court judgment in a case called KOS. It's referred to in the paper. And this is only about 5 months after Kahn, February 21st of 1991, Justice Wetmore, sitting in the British Columbia Supreme Court Trial Division. And he refers, his attention is brought to Kahn, and he then says the following in the fact situation that was presented to him in KOS. It seems to me necessity has a twofold meaning. It must be necessary in the sense of the evidence being crucial to the case. That is evident here. The other aspect, that it is reasonably necessary in the sense of the direct evidence not being available. Now, the following analysis. As a general rule, the Crown is not required to call a witness in which the prosecution has no confidence. This usually relates to matters of credibility. In this case, it is not a question of credibility, but capacity. The child either will not or cannot recount the events as acknowledged by both counsel. The difficulty is that in the second aspect of deciding whether the hearsay evidence is reliable, I must make a judgment on the capacity of the child to relate even to her grandparents about what she perceives to have occurred. So at least the judge recognizes the sort of dilemma here. If the child cannot or will not recount the events, then wherein lies the test of reliability with respect to recounting the events at some other occasion in an informal setting to her grandparents? In Kahn, the trial judge did have the opportunity of assessing the child, even though he did refuse to accept her testimony. I will not have this opportunity. So, evidence isn't under oath, no cross-examination. Child's not to testify, can't assess demeanor. If we're looking to the inflexible approach of yesteryear, it's out, because we don't have any of the traditional safeguards that can assure us with any confidence of any sense of reliability. Accordingly, I requested Crown Counsel to have the child examined by an appropriate expert. Dr. Mills, a psychiatrist specializing in child psychiatry, testified that the child is a normal 3-year-old. I will deal with his evidence on reliability later in these reasons. I also heard from an experienced social worker who has had considerable association with the child. Both say the child will not discuss the event. They do not think being questioned will cause psychological trauma to the child. Thus, the case does not come squarely within the example Justice McLaughlin referred to in the quotation cited above from Kahn. The experts, however, are of the opinion that counsel are correct, that no worthwhile evidence would be forthcoming if the child was called as a witness. In that sense, then, direct evidence is just as unavailable as it would be if the child could not be called because of potential psychological damage to her. Well, let's, again, take a step backwards. Take a look at this. We've got a child who either cannot or will not recount the event. We have got some statement that the child made to the grandparents. We've got a child who is assessed as a normal 3-year-old. We have a child who will not be psychologically traumatized by giving evidence in whatever protected framework the evidence might be given in a court setting. We've got no ability, however, or at least no predictability as to whether or not, even in that setting, she'll provide any useful evidence or anything that would advance anyone's case with respect to the matter. And in fact, the psychiatrist seemed to indicate that the child will not talk about it. So Justice Wetmore has this dilemma. The more difficult decision is in determining the reliability of the hearsay evidence. Again, the absence of an opportunity of assessing the particular child does not make the problem easier. I would have thought it made the problem impossible, but call me naive. Here again, however, the expert evidence is of some assistance. I refuse to hear the opinion of Dr. Mills as to whether this particular child was lying or telling the truth to her grandparents. Good. This is a question of fact for the trier of the case. I did receive his opinion that the child is a normal 3-year-old, and without quoting him, has the classic frankness, but also the limited capacity to think in terms of logic and progressive reasoning. Their statements are reactive as a rule. That is not to say children do not also lie on occasions, but this is again reactive, and to avoid consequences such as punishment. The classic case of the broken cookie jar and both children telling the irate parents that the other did it. Reviews Kahn briefly and then says, what I take from Kahn is that the reception of this hearsay testimony must have that degree of persuasiveness that it may be found truthful when weighed with the other evidence. In making that judgment on reliability to determine whether such evidence is receivable, such considerations as capacity, opportunity, and motive to fabricate must be weighed in determining reliability, not ultimate truthfulness or accuracy, as it may finally be determined by the jury or judge in arriving at findings of fact. Again, after then reviewing the specific statement made to the grandparents, Justice Wetmore says, I have concluded I should permit the hearsay evidence to be tendered. The disclosure was spontaneous and arose in explaining her severe discomfort on urinating. The questions were not suggestive of answers. The child is adequately articulate and bright to appreciate what she believed occurred, and her report is not cluttered with an affront to her moral values or any particular dislike of her father. He then quotes exactly what I quoted before from the judgment of the Court of Appeal for Ontario, Robin's very succinct analysis of children's evidence and this acceptance, and this, I suggest, acceptance without necessarily anything but our common sense reaction based upon our experiences about the frankness and truthfulness of children and their unlikelihood to be engaged in fabrications involving sexual perversion. It seems at that stage that KOS is an example perhaps of the turning around the adage that Mark Twain provided us with. Mark Twain once said that if you're telling the truth, you don't have to remember anything. In the new age of hearsay, the twin tests of necessity and reliability, it may well be that if you don't remember anything, you're likely telling the truth. Now, in the chronology, and there is really a chronology, there's one case that is sort of, it's not as if this is one-way street. There is some benefit that may well be derived for the defense. My criticism isn't that it's a Crown-oriented rule or that simply evidence that traditionally couldn't be used to incriminate will now be admitted, because there is a factor that involves the admissibility of evidence that the Crown would have in the past vigorously opposed and did vigorously oppose prior to, I think, prior to the completion of the trilogy. And en route there, and prior to Smith, there's a very interesting little judgment in Terra Court of Appeal. It's an important judgment for a variety of reasons, the two-pronged reasoning issue with respect to reasonable doubt, the case of Miller. This is November 15th, 1991. And it's important, if you take a look at the chronology, we have, once again, Kahn in September of 90. Smith doesn't come to us until August of 92. So there's a 2-year period between Kahn and Smith. And during that period, generally speaking, and perhaps Miller is one of the real exceptions, generally speaking, people are applying Kahn in a limited way to cases of sexual assault involving children. And that's certainly the overwhelming application of Kahn during that 2-year period. But Miller is an exception. Miller demonstrates that there's part of the message of Kahn that has broader application even before the Smith case has clearly articulated that it does have much broader application and really is the new rule. So in Miller, in November of 1991, it's a second-degree murder case, and this is the court was Justice LeCourcier, the late Justice Tarnopolsky, and Madam Justice McKinley, and no one authors the judgment. It's a by-the-court judgment, which is rather unusual, but there are very few examples, really, of by-the-court judgments. But there is a very interesting hearsay analysis, because there were out-of-court statements by the deceased. And we'll get in briefly at the end of this to a little bit of analysis of some of where dying declarations have gone. But nevertheless, the court refers to the following: that it was important to the defense to establish that the deceased was still alive when on the morning of her death, Mr. Miller left the apartment. So it's clear Miller is with the deceased Wendy Howard. It's important that you try to establish she's alive when he leaves. The defense sought to rely on the evidence of two people, the appellant's mother, one of them, that Miss Howard was alive when the appellant left. Counsel for the appellant concedes that other statements of the deceased introduced into evidence and favorable to the Crown, so we have statements of Wendy Howard favorable to the Crown that did satisfy some of the traditional rules, such as her intention to do the laundry, such as her intention to go out drinking that evening, did bear upon her state of mind with respect to the possible commission of suicide, and were admissible as such. Excuse me. However, he argues that Miss Howard's statement that a friend had just left the apartment could in no way bear upon her state of mind as suggested by the trial judge. Well, that was a statement that that was included. Now, the statement they want in, while this hearsay statement attributed to the deceased is not admissible under any of the recognized exceptions to the hearsay rule, counsel for the appellant takes the position that the Supreme Court of Canada in Kahn rejected a rigidly categorized approach to the hearsay rule in favor of a fairer and more flexible approach. This is Mark Sandler arguing this case. Mark trying to apply Kahn to his situation where he wants something admitted that was otherwise inadmissible. our court says, although the reasons in the Conn case refer to this flexible approach in the context of the evidence of children of tender years in cases involving sexual offenses, both the comments quoted above and the court's reference to its decision in Aries and Venner and the dissenting reasons of Lord Pearson Myers indicate approval of a more flexible approach where warranted by the circumstances. The two requirements emphasized by the court for admitting such evidence are necessity and reliability. Now, the court then says, here it is the accused, rather than the Crown, who wishes the hearsay evidence in question to be admitted. It is not only in his interest to allow admission of this evidence, but its admission also balances the admission of hearsay evidence at the behest of the Crown to show the frame of mind of the deceased. In the present case, the trial judge did not consider either necessity or reliability, since he was of the view that the statement was not admissible to prove the truth of its contents. Now, what's the Crown's position? The Crown argues that the hearsay evidence, which does not fall within an established exception to the hearsay rule, is presumptively unreliable and inadmissible, and that only in cases where the courts have recognized a peculiar stamp of reliability should hearsay evidence be admitted for its truth. At minimum, it is argued there must be an evidentiary foundation which establishes that the declarant is particularly worthy of belief. That may be so, but in this case, where other evidence was admitted against the interest of the accused, it becomes important for the fairness of the trial and to allow the accused to make full answer in defense for the trial judge to consider the necessity and reliability of the statement of the deceased. Many other statements made by her in her telephone conversation with Stair were supported by other evidence indicating that at least a major portion of what she said to Stair was reliable. We're of the view that given the importance of this evidence to the accused, given the relaxation of the hearsay rule by the Supreme Court of Canada, where the evidence favors the position of the Crown, it is at least as important to look at the questions of necessity and reliability of the hearsay evidence when it's favorable to the accused. The impugned evidence should have been admitted for the purpose of supporting the position of the defense. So, I mean, in fairness, this notion of fairness now comes into play, so that it would seem that there might even be a more relaxed rule, particularly where evidence has been admitted through the new standards of admissibility of hearsay unfavorable. Then at least one must look at the possibility that if there is hearsay favorable, and even if that hearsay isn't as strictly supported by the necessity and reliability standards, then Miller gives you at least a position to advance that, in fairness, if you're going to admit hearsay unfavorable, then let's admit some hearsay favorable if it exists. We then get to Smith, and really, I see my time is moving on, and I'll try to be as brief as possible about Smith, and I do want to get to KGB briefly. Smith, once again, is murder. It's a 7-member court, all of whom still are on the court. It's the current court, with the exceptions of LaRue Dubé and Major, who didn't participate in the panel. In that case, it was second-degree murder. It was the position of the Crown that the deceased had driven with the accused from the United States to Canada, where the accused had hoped to persuade the deceased to smuggle drugs back into the United States for him. The Crown's position was the deceased refused. The accused left the deceased in a motel room, returned for her on the trip back to the United States, and had killed her. The Crown called a witness who testified that she had been taken to Canada under similar circumstances as the deceased, and that's really why they end up getting a new trial, by the way, and that she too had refused to smuggle drugs for the accused, but that she had not been harmed by the accused. And then there was the evidence of a series of telephone calls by the deceased to her mother. In the first call, the deceased said that the accused had abandoned her at the hotel. She wanted to ride home. Second call, the deceased said the accused had still not returned. The deceased's mother testified she then telephoned and arranged for a taxi to take the deceased home. taxi arrived at the hotel but refused to take the deceased because the credit card she'd been using had been confiscated at the hotel. The third call was traced to a paid telephone in the hotel lobby made shortly after the taxi left. In this call, the deceased said that the accused had come back for her and that she would not need a ride home after all. The court held that the evidence of the witness who testified as to the earlier incident involving the attempt to smuggle drugs was inadmissible. That leads to the new trial. The court held that the first two telephone calls by the deceased to her mother were admissible only for a limited purpose to establish her state of mind, and that the third call was inadmissible. That was at trial. Now, Lemaire, speaking for, actually, Lemaire speaks for 5 members of the court in this case. There is a concurring opinion by Corey, with whom Justice LaRue DeBay agrees. Let me limit this as much as possible. After reviewing the statements and reviewing the notion of the present intention exception to the hearsay rule, and that would have been the reason for the admissibility of statements 1 and statements 2, the court viewed the position and that finally, that in respect to the operation of the present intentions or state of mind exception to the hearsay rule, the Court of Appeal was not in error. So the Supreme Court, first of all, says Court of Appeal for Ontario correctly decided the issues on statements 1, 2, 3 using the categorical approach, using the exception to the hearsay rule approach. Chief Justice Lemaire then says, this, however, is not fatal to the appellant's case. This court has not taken the position that the hearsay rule precludes the reception of hearsay evidence unless it falls within the established categories of exceptions, such as present intentions or state of mind. Indeed, in our recent decision in Regina and Kahn, we indicated that the categorical approach to exceptions to the hearsay rule has the potential to undermine rather than further the policy of avoiding the frailties of certain types of evidence, which the hearsay rule was originally fashioned to avoid. It has long been recognized that the principles which underlie the hearsay rule are the same as those that underlie the exceptions to it. And he then quotes extensively from Wigmore, then quotes, one has to remember, quotes extensively from Wigmore on the hearsay rule definition, the exception to the hearsay rule definition, of the criteria of necessity, of the criteria for trustworthiness or reliability, or what Wigmore referred to as the circumstantial guarantee of trustworthiness. So that Chief Justice Lemaire then says, well before the decision of this court in Kahn, therefore, it was understood that the circumstances under which the declarant makes a statement may be such as to guarantee its reliability irrespective of the availability of cross-examination. I stop there for a moment. That's a statement of the obvious. That's a statement which supports the categorical approach to hearsay. Because long before, or well before, the decision of this court in Kahn, it was understood that the circumstances under which the declarant makes a statement may be such as to guarantee its reliability, irrespective of the availability of cross-examination, refers to the circumstantial guarantee of trustworthiness, which was a condition precedent to the creation of an exception to the hearsay rule using the categorical approach. So guarantee, Chief Justice then says, as the word is used in the phrase circumstantial guarantee of trustworthiness, does not require that reliability be established with absolute certainty. Rather, it suggests that where the circumstances are not such as to give rise to the apprehensions traditionally associated with hearsay evidence, such evidence should be admissible even if cross-examination is impossible. Then goes through more Wigmore and says, what I started off with, the principal basis of the hearsay rule and its exceptions was thus understood by commentators on the common law of evidence early in this century. The decision of this court in Kahn, therefore, should be understood as the triumph of a principled analysis over a set of ossified, judicially created categories, which, with great respect, rely upon the same principles as the principled approach. Then, it is no accident that the criteria identified by Justice McLaughlin and Kahn bear a close resemblance to the principle of necessity and the circumstantial guarantee of reliability referred to by Wigmore, and that's perhaps the change. Because the principled analysis, Chief Justice Lemaire realizes now, isn't quite the same, and he uses the words, they bear a close resemblance to the principle of necessity and the circumstantial guarantee of reliability. So what it is, it's a relaxation of the more stringent test of reliability and necessity that was created by Wigmore. And then he reviews Kahn and says the court's decision in Kahn therefore signaled an end to the old categorical approach to the admission of hearsay evidence. Hearsay evidence is now admissible on a principled basis, again using that term, the governing principles being the reliability of the evidence and its necessity. And then goes on to talk about necessity and reliability in the New World order of necessity and reliability. But if you compare the words used in Smith to the words used in the Wigmore definitions, I suggest with respect, these words are close and bear even a closer resemblance to the Wigmore standards than the words used by McLaughlin in the Kahn case. Very briefly, we move as quickly as possible because of time constraints to KGB. And this is just a very innovative application of the same principles. And as most of you will well know, KGB was the young offender case where a variety of witnesses who had given videotaped statements recanted their statements at the time of trial, and their statements were put to them as previous inconsistent statements reduced to videotape. The trial judge, applying the appropriate principles of law as they then existed, quite properly used the inconsistent statements only as a test of their credibility, but not for the truth of the videotaped statements. Court of Appeal upheld that view, it being the traditional and sanctioned approach by the Supreme Court of Canada and Deakin and a long authoritative line of cases. Well, in KGB, we now have a rejection of that with a notion of, first of all, a justification for doing what the Supreme Court of Canada called rejecting the complexity or technicality of the Orthodox rule. And it's the Orthodox distinction between permissible and impermissible uses of prior inconsistent statements. And so what then becomes applied to this notion of the previous inconsistent statement are the same standards as are applied in Kahn and Smith, namely requirements which address the dangers of hearsay. The new admissibility rules are based upon necessity and reliability. Now, I don't have time to go through it, but the reliability feature here is perhaps more stringent than you see in Kahn, more stringent than you see in Smith, because we're dealing with the new use to be made of a special category of evidence, and there is to be a greater independent sense of the circumstantial guarantee that the first statement or the previous inconsistent statement has some sense of reliability in that it was either under oath in some fashion or, as in a video statement, has a guarantee of its intrinsic or inherent reliability. One very brief follow-up, and this is a very recent judgment because we're going to see new uses to be made of the necessity and reliability principles, and it will become the hallmark for admissibility generally. You still have relevance, but after relevance will come necessity and reliability as the standard benchmarks as to how criminal trials will be operated and what evidence will be viewed as flowing into a trial. We seldom have seen dying declarations. Dying declarations is something that you more often see in law school than you see in the practice of law. And yet, there was one recently in Newfoundland. People in Newfoundland talk as they die. And it's a case called Karsekin, K-H-A-R-S-E-K-I-N, 88 CCC 3rd 193, March 8th of 1994, Newfoundland Court of Appeal. And in that case, a review was made of the traditional rule relating to dying declarations, and most notably this concept of a settled expectation of death, which was a hallmark and the basic foundation to the circumstantial guarantee of truth of the dying declaration. And this was based partially on traditional notions that, first of all, if there was a settled expectation of death, that there is no temporal, self-serving purpose in the person facing death to lie, that there was a traditional notion that if the dying person believed in a higher power, that they would also believe that they would be facing their punishment for untruthfulness so soon thereafter after the lie that they might be dissuaded from lying, and that even if they didn't believe in a higher authority, that there was an instinctive awe that related to impending death that would be a sense of would bear the stamp of truthfulness. Well, it appears that the new world of hearsay and the new tests of reliability and necessity are also godless, and we no longer require the same sense of settled expectation of death. We no longer require a sense of impending doom or facing one's maker in order to give the sense of circumstantial guarantees of truth. The Newfoundland Court of Appeal liberally applies Kahn and Smith to dying declarations, and essentially finds that sort of the reverse of the notion that traditionally applied to dying declarations. What they found was that there was nothing in the circumstances that suggested a reason to be untruthful. So that if you don't find anything in the circumstances that would lead you to be suspicious as to why the person might be untruthful, then the notion that there's a settled expectation of death isn't a prerequisite to the admissibility of the dying declarations hearsay, because that should give us a sufficient level of comfort and as to the reliability of the statement. Again, I return to the beginning. Necessity and reliability are flexible criteria, but I suggest with great respect they're vague and they're subjective, and so subjective that they will lead to varying applications and a lack of uniformity in the way in which evidence at trial will be heard. We'll be experiencing uncertainty and confusion, and I suggest that it will be many years as we begin to develop criteria and guidelines for the admissibility of this type of evidence, which ultimately will probably lead to simply new criteria for categories. Thank you.
Thanks, Brian. We'll take the morning coffee break.